Hello and welcome to today's remote session. This is Tom Bechtold, of course, your host from SecureWorld Digital. This is one of my favorite segments that we're doing. We've been doing these quarterly now for a little bit. Ask a Lawyer. Cyber law and privacy concerns for 2024. That's what we're talking about today. We're going to take audience questions as well. So if you have a good question, please throw it in there. We'll try to get to as much as we can. I have a lot of questions that I have for the group, but certainly, time permitting, we're going to try to crack into as many as we can. So just want to say thank you to everybody joining us today, all of our panelists. I was having fun with AI yesterday when I was making the slides. So thank you to Tomco, that's me, for making this one possible. This one's not a sponsored one. I don't like having everything sponsored. So I thought it'd be fun to just kind of say, hey, this one's on me. So everybody enjoyed today. Your stuff's not being sold to anybody. So I think that's great. So just wanted to say, hey, we've got some resources in the list. We're going to reference a couple of different articles, 3 articles, and 2 of them I actually have loaded. So there's one that Mariah did. You'll meet her in a minute. And Jordan, they both did articles for us in the last couple of weeks. I've got those loaded in the resource tab, so you might want to check those out. We're going to talk about some of those things. Like I said, we're taking questions throughout. If we can, we'll try to answer your questions. After about 45 minutes, you'll have that CPE, Certificate of Attendance, available that you can download. If you have any problems with that, just shoot me a quick email. I'll try to send one over to you. If you have any audio or video issues, I keep having some audio video issues myself this morning. So refresh or F5, function F5, sometimes that works. If you have real problems, switch browsers. Chrome, Firefox, and Edge work pretty well on 24, so check that out. If you're really having a hassle today, Venus in retrograde or whatever they say, I'm recording this, so come back and check it out later or tomorrow or whenever you're free. So, and of course, because we are recording these, share these with colleagues. Lots of valuable information, hopefully that we're going to share with you today. So please share that with your friends. Normally I say stuff here. This is just part 3 of our series, Ask a Lawyer. So we're going to have a 4th one, hopefully in Q4 at some point. I'll figure that one out with our group, and then we'll get that out there for everybody to check out. So. Keeping true to form, all of our same presenters are back. I love that we have the same group again, so it's kind of a little camaraderie between the 4 of us here. But we've got Jordan Fisher, founding partner and owner at Fisher Law. Big round of applause out there virtually, if you wouldn't mind. She just started this endeavor. She was with a different firm before, but now she's like, you know what? I'm doing this on my own, and I'm doing it. So congrats, Jordan. Mariah Jaworski, again, one of our authors of the week on the newsletters, articles, so check that one out. But we're going to hear from her in a bit. Violet Sullivan as well. We're going to have her at the AI virtual conference in a couple of weeks, so you can see her there as well. But I would say look for these folks at the in-person events as well. They have awesome content when they're in person on their own. All different locations too. So check for them on our events pages. These people know a lot of stuff, and when it comes to legal, they're not going to steer you wrong. So that's all I'm going to say about that. Let's get into some stuff though. Jordan, since you're on the top of the list, and I gave you a huge kudo there, why don't you kind of kick us off, if you don't mind? Give us your background, and I kind of gave you guys a little bit of a something, if I'm not mistaken, about your intro. Why did you get into law as part of that? So if you wouldn't mind, tell us a little bit about yourself.
Yeah, so my name is Jordan Fisher, and thank you, Tom, and the kudos. Very excited. I've been an entrepreneur for most of my career. So for those of you that have known me for a number of years, this is not shocking that I'm now going back into, owning my own law firm and practicing in that way. So I'm super excited for that journey and what that's going to look like. But my area of focus is really on proactive regulatory compliance in the data privacy, cybersecurity, and technology law areas. I really enjoy working with businesses to understand what's going on, although increasingly that seems very challenging as more and more laws are being adopted. But my background is I really got started in this space by clerking on the European Court of Justice in the EU, which is, for those of you who don't know, is the highest court in the EU. So think of it as our US Supreme Court, but on the EU side. And I was there in 2013 when GDPR had not been adopted, but privacy was still a fundamental right. So my introduction to privacy and security was through that European lens. Coming back to the United States, really could see what was going to be happening here and sort of recognizing the increasing role of data in businesses. And from there, really created this career that sort of spans multiple different jurisdictions, and helps businesses in the US to understand those global and US requirements. And it has only gotten more complex. I actually was laughing about this, having started my own firm. I started my first law firm in 2017. And at the time, there was no privacy game in town, really. And the GDPR went into effect in 2018, and here we are 6 years later, and I can no longer count on two hands the number of privacy laws that we are actively dealing with, and it's growing and growing. So definitely super interesting. The reason I got into law, I was incredibly fortunate. My father's an attorney, so I was introduced to lawyers at an incredibly young age, and that really gave me sort of that first foray into it. But the reason I personally wanted to get into law was my senior year of high school. Our high school had this opportunity for 3 weeks you could do a vocational experience. And my dad was great, and he set me up with 3 different women practicing law in different ways. One was a female judge, one was a female DA, and one was a female in-house attorney. And that real wide perspective on the law let me see how incredibly interesting it is to practice law. You get to do so many different things. I feel very fortunate that I'm in an area of data privacy and security that I personally love, but the ability to pivot and work with businesses, work with society, work in so many different ways, there's just so many different opportunities. And that's what really attracted me to the law. I didn't feel like I was going to have one career path. I felt like I could really have a variety of different careers with that legal background. So that's what really sort of attracted me to it. And I love being a lawyer. I can't say I always love the way we practice law, but I certainly love being a lawyer, that's for sure.
Appreciate it. Thank you so much. And you really do. You educate folks. You're also a lawyer. Maybe one day we'll see Judge Fisher. Who knows, right? So, I mean, why not? No.
No, I think being a judge takes a certain, in today's environment, I think being a judge, you really need to have a certain personality. So I commend those that are on the bench, because it has gotten only harder in recent years, that's for sure.
I'll bet. Thank you for being here. Let's move over to Mariah Jaworski. Welcome. Same thing. Give us a little bit of your backstory and why you got into law.
Great. Thanks, everyone. Hi, Tom. Hi, Jordan. Hi, Violet. Great to be with you again. I'm Mariah Jaworski. I am a data privacy and cybersecurity litigator at Clark Hill. Clark Hill is an international law firm with offices throughout the United States, Ireland, and Mexico. I actually started my career with the United States Department of Justice, representing federal agencies and defending the actions of federal agencies. And we're going to talk a little bit later about some developments in the law and the sort of overturning of what's known as the Chevron doctrine. So spoiler alert, I have some pretty personal and insight into that. I got into law because I wanted to wear that white hat. I wanted to really represent the will of the people. I was very motivated at that time to try to advance certain goals and policy initiatives. And my foray and real pivot into the data privacy space came through data breach. So around 2013, I moved into private practice. I started our firm's crisis response team. At the time, we thought crisis response was going to be a lot of spills and explosions, kind of physical impacts to environments. And in fact, it wasn't. It was data breach. It was impacts to digital environments. So between 2013 and 2018, did a lot of data breach litigation, sort of first wave data breach litigation. And then 2018, same sort of era as Jordan, with the rollout of the European Union's GDPR and the advancement of privacy laws in the States, really started pivoting into the privacy space. Currently, the majority of my docket is representing businesses in defense of privacy and security class actions and in technology disputes. I'm a litigator and I'm in court.
Okay, excellent. Appreciate that. Thank you so much. It's nice that we have Jordan, of course, representing the small firm. Of course, she's been with other larger ones, but then you're with the big one, right? So kind of a nice variety that we've got working on here. Over to Violet Sullivan. Violet, welcome. Adjunct Professor, Baylor School of Law, AVP Cyber Solutions at Crum and Forster. Welcome. Tell us a bit about yourself and why you got into law.
Well, I know Crum and Forrester sounds like a law firm. It's actually an insurance carrier. And I'll add to the perspectives. You say it's nice to have different people in every area. Jordan is very focused on that preventative privacy. Mariah's the cleanup crew that comes back with litigation, right? So it's two different sides of the law too, where we all three work on totally different areas, but we still learn from each other. And that's why I love being on this. I am on the insurance side, so I'm a lawyer that turned more tech. I've been on digital forensics teams and worked to both prevent the issue and make sure that the clients that are asking for it get the right kind of remediation, but also be that crisis management response. And I've been on the breach notification side for supporting groups like Jordan and Mariah in responding to crisis. And I love doing this on the insurance side because now I get to use my war stories and experiences to help people who have cyber insurance get aligned with free cyber resources, cyber solutions, hence my title. And I love teaching about it. So how did I get into the law? I had an uncle, similar to Jordan's story about her dad. I had an uncle that was very much an Atticus Finch character. He practiced defense of criminals, and he gave me a heart for defending the defenseless in the justice system that showed me, compared to Mariah's idea of the white hat, it just showed me how no matter what there are people accused of or sued for, there's always two sides of every story. And I think that that's even true in the cyber privacy world. And it's an honor to have my license.
Appreciate that. Thank you so much. Let's get into some questions. Starting out, like I talked about at the beginning, I want to get like an update from the group. But I'm going to ask Jordan, if you wouldn't mind. We actually got a nice article from Jordan on the July 1st. There was a lot of several states adopted new privacy laws. Jordan was kind enough to give us a great paper on this, really kind of spelling it all out. But if you wouldn't mind, give us kind of the quick rundown, if that, quick, quote unquote, a rundown on what happened on July 1st that was so significant. And then feel free to chime in, Violet and Mariah, how that affected you.
Yeah, so I'll dive in. I think before I get into specifically July 1st, I think it was stepping back and saying, in the United States right now, we're at a really interesting phase, is what I'll call it, because I don't want to say period of time. It's going to probably, I'm not sure how long it's going to last, but where a number of different U.S. states are adopting what we're generally calling comprehensive privacy laws that are applicable within those states. California led the charge in 2020 with the CCPA, and since then we've had a number of different states. And so what has happened now is we're feeling like about every 3 to 6 months, we have states who have adopted these laws that are then going into effect, because the trend is typically they're adopted, let's say they're adopted on January 1st of the year. They usually don't go into effect until 6 months later or a year later. And so these adoption dates and effective dates are really important to track if you are dealing with privacy laws, because it usually gives you some period of time to come into compliance with the law. So it happened on July.
Jordan, I think it's important, especially for a technical audience, to say the things that caught our attention in the last 20 years have been the rules around what happens when a breach happens or with a cyber incident that exposes data. What Jordan is talking about is that new wave since GDPR and since a lot of the international expectations of privacy have come over, and leading with the CCPA, like she mentioned in California. It's now this issue of people worrying about privacy before a breach, where you hold the data and how you hold it.
That's a really good point. I think that's been a very important shift to recognize, is that a lot of things used to be post-incident. Now we're talking about proactive. You need to do this if you are triggering the law's requirements. That's a really good point. So on July 1st, what happened was 3 states who had previously adopted their laws actually went into effect. And those 3 states were Florida. I'm going to make sure I get these right because it feels like you're always changing. Florida, Texas, and Oregon. And so what that means that as of July 1st, if you need to comply with the Florida privacy law, the Texas privacy law, or the Oregon privacy law, you need to have started to comply as of July 1st. I'll say that generally speaking, when you're looking at these laws, there's a lot of commonality, right? We're not seeing drastic differences. I think that in this certain set of 3 states that went into effect on July 1st, there's 2 buckets. There's Florida, and then there's Texas and Oregon. And the reason I say that is that Florida's law, out of all the different states who have been recently adopting laws, is very distinctly different because it is looking at very, very large entities. And if you know anything about Florida, and you can guess what large entity sits in Florida, that is Disney. This law, in a lot of ways, feels very geared towards one company specifically, which was Disney. And the reason is that the revenue threshold is so much higher than you see in any other of these comprehensive privacy laws. So for 99% of businesses, Florida is not going to be a law that you have to deal with, at least in its current iteration. So that really leaves, for most businesses, July 1st impact is Texas and Oregon. And for the most part, those laws generally seem to be trending towards what other comprehensive privacy laws are doing, which is requiring that you have proactive privacy notices that provide the categories of information being collected, what you're doing with that information, third parties you're sharing that data with. They have things like data rights. So these are things like data access requests, data deletion requests, et cetera. So for a lot of businesses that have already been dealing with some privacy law in another jurisdiction, coming into compliance with Texas or Oregon is most likely going to be a less of a burden than sort of it would have been 4 years ago, right? So we're seeing this sort of build upon each other. I do want to call out a couple of areas when I'm looking at these laws that I think are important for businesses to be thinking about. And the first is, do I need to comply with it, right? So are you doing business in these jurisdictions? Are you triggering based on the triggering needs, which is mostly number of data that you're collecting, or if you're a data broker? Assuming that you need to comply with it, key things to look at are the exemptions to the law. So for example, most laws are exempting nonprofit organizations. Oregon does not do that. So, for a lot of businesses, that could be impactful if you're a nonprofit.
Doesn't either, right? Texas.
I don't know if Texas exempts nonprofits, but Texas has a different look at it. They're looking at small businesses as defined,
I think
right?
The point is, when they look at small businesses, they don't take out nonprofits. So I think that was just something I'll throw in there.
Right. And you can see here, even as we're all talking, I feel like a lot of times I need to have these laws up in front of me, and you do need to take the time to look at these nuances, right, where they are different, to make sure that you're understanding what is exempted and what is not. And then from there, it's looking at what is required for your privacy notice, what are the rights. 99% of the time, they're the same as these previous state privacy laws, and they're the same as the ones that are coming down the pike. And then any other sort of nuances, I would say, of these laws. So my take on July 1st is, it's important to know it happened. It's important to recognize if you need to come into compliance with it. But I don't see it as neither of the Texas or the Oregon's laws are a seismic shift, right? They're not taking some aggressive approach in one direction or the other. Florida, again, is so separate. I don't even think it's worthy of conversation because most businesses are not going to trigger it. And it's framed slightly differently as well. And so that's actually, I think, a welcomed message for most businesses, which is you're not going to trigger that law. But so that's generally overview. We can go into more details, but I'll pause to see if Mariah or Violet have additional thoughts on it from their perspectives.
I'll just jump in and ask you, Jordan and Violet, to the extent you have visibility, to what extent does Texas and Oregon, and this idea that we're now almost at a threshold, right? 13, 14 enacted state laws. Are you seeing your clients now say, we're just going to roll this out nationally? Because that is one approach to privacy compliance, right? I'm not going to have a piecemeal state-by-state approach. I'm going to try to have a standardized offering to consumers throughout the United States. Or Jordan, are you seeing, no, we're still really interested in having our California program and our, Oregon program and our Connecticut, Utah, et cetera?
I think it depends. A great lawyer answer.
Did I freeze?
Your voice is still coming in, but your video is frozen. But so I think it depends. And I'll say from my perspective, if you are a business that is,
am I here?
Like a business to consumer, Mariah, you are coming through. Oh. If you are a consumer-driven business where data and the ability to harness the value of that data is incredibly valuable, I'm finding that you're more likely to take some state-by-state approaches. And most of the times that is in the context of data rights and some of the nuances that might come from the state. But your back-end infrastructure is usually cohesively applied across the entire back end, right? So you're not coming up with sort of a California-based approach to the back end that's different from your Oregon-based and Colorado and Virginia. If that be so, put those businesses to one side, because I think they're the ones that, and frankly, where it really matters is data deletion and data retention, et cetera. They want to keep the data for as long as possible, and so they want to have a state-by-state approach because it is more valuable to them to retain the data than to have one cohesive approach. For businesses that data is used for sort of transactional purposes, but they're not really doing a ton of targeted advertising, they're really almost like B2B type businesses. That's not really, they happen to have data, but that's not driving their business forward. They're just saying, we're just going to apply the same thing across all the board. We're going to take the most restrictive approach. It doesn't make sense financially or resource allocation perspective to divvy it up based on different states. That generally seems to be the case. Now, I will say as more and more states adopt laws, I think you're going to see more and more businesses take that more comprehensive approach and just say, listen, we can't train the team on 50 different laws. So they're going to do that. And especially that makes a lot of sense when you're seeing these states adopt very similar laws too, right? We don't have these drastic differences between them. But that's what I'm seeing right now. I don't think we're wholesale all just saying we're going to apply it nationally. But I do think for a lot of businesses, if the data doesn't have value to it, applying it nationally just makes sense at this point.
And I'll talk from the claims perspective in insurance. I see when things go wrong, and we see when people are saying, hey, we are getting sued, so let's see if our cyber insurance policy covers it. Reminder that I am speaking on my own opinion and not that of my company. But I think it's also fair to acknowledge that there are still people that aren't smart and going to their attorneys and asking about, what do I do with all this data? There's a lot of still what privacy laws and people sticking their head in the sands and not changing or doing anything because there's not a federal privacy law, and it doesn't look like we're going to get there anytime soon. I think that some people just get really overwhelmed and then they crawl back into their shell.
Yeah, I would agree with Violet. I mean, I always joke, 6 years ago, I was telling everyone how to spell privacy. I don't think I have to tell them how to spell it anymore, but they certainly don't know much more than that. Especially when you get out of very privacy heavy industries and into off the coast, you are still very fortunate if they're working with anyone, not even a lawyer, but anyone to understand their data and managing their data. So I would definitely agree with that. That perspective.
And one reason for that might be that the majority of these laws only have provisions for attorney general enforcement and not for private citizen or consumer enforcement, although California's law does, as does a sectoral Washington state law. But certainly as we see attorney generals get more budget and more active in the privacy space. I know the Oregon Attorney General in particular, I had seen recent news reporting about some of the funding that they've received to really prioritize privacy. We might see businesses outside of the coasts take it a little seriously as well. And then one thing I wanted to mention is there's a question about a crosswalk of basic compliance requirements for all of these state laws. Yes, there are crosswalks. A lot of organizations like the IAPP has some good resources and crosswalk-oriented spreadsheets and materials. Working with outside counsel, also we have our own internal crosswalks that we've created. But a crosswalk is a really great, or just an Excel spreadsheet,
Maria,
candidly,
is this a new word that you've developed? Because I've always heard of like spreadsheets,
No, I've heard of
right?
it.
Like the basic stuff, but I hadn't heard crosswalk.
Crosswalk is comparing
Crosswalk.
regulatory requirements in different regimes.
I'm so glad you taught me something today.
Yeah.
Thank you.
Well, give credit to Diane Mickelson, who asked the question.
Yeah, thanks, Diane. I hadn't heard that one either, so thank you.
So another question that we got that I'll just jump in. Have you seen a scenario where an organization may decide not to do business in a state? That was a conversation back in 2018, 2020, when especially the CCPA was rolled out. Like, should I just not do business in California? And we also hear from companies a lot with respect to biometric privacy issues. Should I just not do business in Illinois, which has a very punitive biometric privacy act? In general, you know, California is the 5th, I think, largest economy in the world, not just in the United States. That's a huge business opportunity and a huge loss. So I've had a lot of conversations with clients and businesses where they've fronted, like, maybe I'll just segment my audience and I won't offer these goods and services to a certain state. I have not seen it in practice. Jordan and Violet, I'm interested if you've seen a company actually implement that type of approach.
I would say it's similar to you. I mean, I think in 2018 it was, well, if with GDPR, if we're not really doing a ton in Europe, there's no point in pushing for it. In 2020, California. At this point, I mean, you're just delaying needing to deal with this, and I think that it's becoming harder. If the business opportunity is such that it's more advantageous to go into the state, I'm not seeing that question come up as anywhere near as much, to be honest.
It's coming up theoretically. I know on the insurance side, there were questions. I mean, this was before I even came on the insurance side. I remember people asking me about how to draft an exclusion for BIPA, right? I don't even do the drafting of the paragraphs in the policies, but I do think it's interesting that theoretically it does come up, because the question is there going to be enough reprimanding, wrist slapping, and litigation that's going to cost money? That's something that insurance companies are always thinking about, is like, what is the future harm that might occur financially? So I've only seen it theoretically, and I haven't seen it recently. I've, like 3 or 4 years ago, there was the questions, but it only came from 1 or 2 people asking me.
Okay, let's switch gears, because I think we could talk about privacy laws and states and forever almost. But let's switch gears to, I want to go to justice, if we could. Let me get to the right slide.
Did we get to bring up Chevron yet?
Yeah, we totally can.
Okay.
We totally can, because I want to see Mariah get fired up. But no, seriously, I want to talk to you guys about, we had the SEC stuff. We've had stuff from our big court. Let's talk about what are some of the things that are happening justice-wise, or people getting their hands slapped, things of that nature. Mariah, you're the litigator. Why don't we start with you? You had also an article, which is in the resource tab. And before I continue, I forgot to say this at the top. Everything that these ladies are saying are their own opinions, and it does not necessarily represent their organizations, except for Jordan, because she owns that place. So that's probably fair to say that represents what she's talking about.
I'm not providing legal advice, though. I'm not providing legal advice, so that's my
There's no legal advice beyond. Right. So my half-assed attempt at a disclaimer with attorneys on the line. So sorry, I shouldn't say that at the beginning, but I should have. But anyway, please enlighten us a little bit on, actually, if you wouldn't mind, I don't know what the Chevron thing is other than I can get gas there. So please, what is this Chevron thing, and why did it get reversed?
Sure. So the Chevron doctrine is just a legal doctrine, or a legal principle, really, that had been in effect for about 40 years. When at the time the Supreme Court said, we're called on to interpret laws a lot. And when we interpret laws, we need a framework to understand how these laws should work, right? And the idea of the Chevron doctrine is, when there is a law that's ambiguous, so when, I'm going to use an environmental example, but when there's a law that says we want to have clean water bodies, we're going to defer to the agencies, for example, the EPA, to implement, to tell us what it means to have water bodies that are clean, right? Because we can say, oh, well, does clean mean no pollution whatsoever? Does clean mean, yes, there is some discharges, but only under the certain caps? So the specifics of the law are we're going to defer to the administrative agencies because they're the experts. They have literally technical experts. And we see this at CISA, right? CISA has many cybersecurity experts, non-lawyer expertise. We see this even at the FTC and their consumer protection divisions. These are individuals who have dedicated their lives to various policy areas and who are very much experts in their space. Okay, so for the last 40 years, if there was a challenge to a law, the court would say, you know what, we think this law is ambiguous, but we think that the agency interpretation is correct, or we'll at least give it some deference. Just last week, there was a new Supreme Court decision, Loper. It reversed Chevron. So it essentially says we don't have to defer to administrative agencies anymore. And in fact, we as the courts, maybe we're in as strong a footing to interpret these laws as administrative agencies are. So what does it really do? It's really a reflection of two things. And then I want to turn it over to Violet and to Jordan for their insight. It's a reflection first of this court in particular, feeling that there has just been tremendous government overreach in the buildup of this administrative state, right? There are many politicians, there are many judges who just fundamentally think it is wrong that there is so much power in the administrative branch. And then secondarily, what it does is it shifts that power back to the courts, who are now tasked with interpreting these laws and really substituting their own judgment for what historically was the judgment of the administrative agencies. So I hope that wasn't too technical of an explanation. And Jordan and Violet, interested in your just thoughts on what happened here and what the Chevron doctrine is.
I thought that was a great explanation. I think just kind of the waking up to the fact of saying we have leaned on in prior years, in 40 prior years, we've really leaned on those experts and agencies that are established for this reason to help us make decisions and help keep people accountable. Because the accountability, I think, is something I see from the insurance side, is you see the regulatory fines and penalties, you see the edicts and all of the things that are any agency holding accountable the companies that might stray from what is expected or standard and required in those industries. I think the thing to remember is sometimes the agencies also got thrown out there as jokingly as the fourth body of government, not just judicial, legislative, and executive. Oh my gosh. Well,
I'm trying to think of a third one myself.
So well, that was a weird hiccup. What I guess what I want to point out is, instead of now we are used to tracking, like, what is CISA saying and what is FDA? I mean, this is even going to Food and Drug Administration. This goes to whether fruit is good or bad, right? We are saying all across industries, there's now going to be a switch from who's the authority, and they might still include their information, but now we can go and check on the FDA website. We can go and check on OCR's website for HIPAA guidance. Now we have all these different courts that might have different standards, definitions, rulings, and we're also going to see the people that don't agree with the law as it stands or accountability with the law. They might go forum shopping, meaning they might go look for what areas that they can address the issue with a judge that might be clueless, or a judge that might defer to, being more lenient. I think that there's just more unknown, not that we know it's good, bad, or otherwise. There's a lot more unknown. But interestingly, I was talking on the claim side of this, even if litigation, I think we all can agree that litigation will probably increase, at least in the short term, because we're still figuring this out. And this is the opportunity for people to just make a bunch of money by going in and addressing things that they normally wouldn't have addressed because they knew the standard with CISA or another body. But I do think that it could make regulatory claims somewhat more defensible if we can play into if the argument is that the regulator is more aggressive and now the regulator would not be deferred to as much, you have a more defensible claim, which I thought that was interesting. I wouldn't have thought that unless I talked to the insurance side.
I would just hit on the point that you made, which is the volatility that is going to result throughout the United States, right? So it's true, we have a comment that says, experts are not always correct. And that's true. The administrative state is not always right, but at least they're kind of consistent and stable. Now what we're almost certainly going to get is we're going to get a court in Texas that says this CISA reg is wrong. We're going to get a court in New York that says we're upholding it. That's a worse position for businesses to be in my opinion, at least, than we have this regulation, a CISA reg. We think it's wrong for many reasons, but we're going to go ahead and determine to comply with it because we think that we think that it'll be upheld, right? There's more certainty.
6 different decisions that are on a spectrum, right? And so we might have. You could have all of these A's, and I think it's not just one against one. That's the thing that I think is so crazy, is that it's going to be exponentially harder keeping up with decisions because it's not going to be as evident as something posted in an awareness bulletin that CISA puts out.
Mm-hmm.
Only ones that are going to really be kept up are those cyber attorneys that are the people that are going to be in the know are the cyber attorneys that have to follow this for their job. But general counsels no longer are going to be able to just kind of keep up with this stuff because it won't be in a central knowledge source.
Yeah, I was talking to some in-house counsel. Oh yeah, crosswalking is going to be super important. But I was talking to a general counsel, and she said, "Am I going to have to know how 50 different states defer to administrative agencies to understand my risk in each of those different jurisdictions?" And when you overlay that with what we're heading towards in the United States, and we appear to be heading towards it quite quickly, which is potentially 50 different state privacy laws, and we have 50 different data breach notification laws, my concern is that it's going to become incredibly costly to comply and to really monitor where you're going to be required to comply with different aspects of this. And I mean, this goes back to, I think, a federal privacy law. Federal law can help to sort of add that cohesiveness, but we're not gonna get it. So I agree with everyone. I think it's too early to know exactly how this is going to impact the privacy and security space. Other than that, the FTC has become a de facto privacy and security enforcer, and this could impact its ability to enforce across different states now. So
Jordan,
that's, I think, we want to watch.
Do you think this is why the FTC has been so aggressive in the last couple of years in trying to kind of put their foot in the door?
I don't know if it has anything to do with this Chevron doctrine. I think I think in some ways they're trying to prove a point that we need a law to give them actual authority. Mm-hmm. And then I think in some ways they haven't, I wouldn't even say they've been aggressive. They've been responding, and it's been quite easy for them to find opportunities to, go after businesses, right? Breaches have made it quite easy to open the door to regulator insight. And so I think it's more of a we just have more breaches, and they're headline making breaches, and they're impacting us more. And so that consumer protection aspect is easier to go after them with. I don't know, Mariah, do you have any thoughts on that?
I think it is a personal mission of the head commissioner, Lena Khan. I think that's why the FTC, it's very much her legacy to be what I think she would say is a more aggressive enforcement stance. I think that the FTC's viability as the quasi-privacy regulator in the future is deeply in question because the majority of the actions that the FTC takes is under what's known as its Section 5 kind of unfair competition authority. They have leveraged a very specific statutory provision to do a lot, and they've taken a very broad interpretation. And I think that's now going to be subject to a lot of vulnerability in the courts.
Let me ask you this. I have a very naive question here. Why was this even reversed? I mean, was there something broken about it? Did we need to really fix this? Or is this just like, I don't want to get political about it because I feel like the Supreme Court's just doing weird stuff anyway. But why was this even a thing that we needed to address?
Get political, Tom. This was because we have a 6-3 Supreme Court, and 3 of the new justices are Trump appointees. Others might disagree.
No, that makes sense to me.
Yeah, I don't think there.
I don't like it.
I don't think there was anything outside of that would justify the decision.
Okay. All right, we'll move on. That's kind of what I was afraid of, but okay. I did see a great question in here, though. Let me back up to my Q&A. Ricky, where did you go? Given the court's role in interpreting laws like Chevron in cybersecurity cases, do you believe there's an increasing value for cybersecurity professionals to pursue legal training? And if so, what specific areas or aspects of legal training would you recommend? I like that.
I won't tell anyone to go to law school. It's hell and it's awful, but I'm not going to be too blunt about it. And I won't tell you where I went to law school. I think that there's other ways to affect change as a technology person. I think that there could be legal training available, but I also think that we live in this awesome community. The cyber community is so open and progressive in trying new things and learning from each other. I would just say make friends in a certain group, because I have a privacy law text chain that I ask questions to. I don't know if, I think it definitely would help to have more technical lawyers, but if you're better at the technical, right, I would just hope that you use your skill set to the best ability. I would just not encourage anyone to go to law school, even include my own kids.
I disagree with that. I actually liked law school, but I got a screw or two loose, so I know that.
Yeah. We know you're crazy, Jordan. We know that. That's.
Yeah. I do think if you are already thinking about law, having a technical background in undergrad before you go to law is something I would definitely recommend. Right. So instead of the more traditional, justice majors or English majors, et cetera, which tends to, philosophy majors that tend to go to law school, I think if you're thinking about law and you can do a computer science degree and then go to law school, I think that is incredibly needed. But I think if you're already a cybersecurity professional, you like what you're doing, you don't necessarily want to practice law or do anything in that, I agree with Violet. I don't think going into law would make sense. What I think makes a lot of sense is more of there's sort of these master's programs, there's these online certificates because you need to be able to speak to lawyers, just like I think lawyers need to understand more technology to speak to technologists. But I don't think you need to go to law school to get the level of knowledge you would need to have those conversations. I think you can do that in other ways. But I do think brushing up on your understanding of how lawyers think and operate and how they're seeing the world is incredibly valuable. Just like for lawyers, I think it's incredibly valuable to understand the demands and how the perspectives of the technologists, the business operations, et cetera. This is cybersecurity and privacy we can't bucket it into one issue. So the more you can see beyond your own perspective, I think the more valuable you're going to be, regardless of whether you're a lawyer, a technologist, a business folk, or whatever.
I second everything that's been said. And I would really emphasize the role of these new certificate programs and kind of one-year programs that are alternatives to a law degree.
I would also just caveat, one of the things that I just don't love about the law school program, at least in the US, is that there's this focus on you have to be in a firm to be a real lawyer, or you have to go to the traditional route to be a real lawyer, whether that's in the government or big firm. The things that Mariah, myself, and Jordan do, they're all different than anything we were exposed to at law school. They're all something that's unique and filling a weird niche. And I think I would just say the cyber technical world is way more creative in how to apply their skill set, and the formal schooling of law schools sometimes does not leave open ideas of where you can fit in.
Somebody gonna answer
I have
that?
thoughts on that, but that's more on the legal education, and we can look back to the side.
That's fair. I did see someone say a technical lawyer is a unicorn, and I would totally agree with that. So to the extent, to reiterate, if you have a CS degree, if you have a technical undergrad degree, and you apply for law school, you will stand out. And you will stand out as an applicant in the future to any job, whether it's a big firm, which is not the only universe of law jobs out there, whether it's as a solo practitioner or a boutique practitioner like Jordan, whether it's in-house at a big company where these skills are really in demand, or like Violet working to support large insurance companies, et cetera.
Excellent. Let's move gears, or shift gears rather. I guess you don't really move them. You shift them, or you just let them roll, I guess. But let's go to AI because, why not? Because AI is always fun. AI generated image here, which I thought was kind of fun and cool. But I wanted to talk a little bit about this in general. I would probably do a whole segment on it, for an hour. But let's talk about AI. When are we going to see like people changing their privacy policies that include AI verbiage? That hey, yeah, we're using AI. We're going to sell your stuff and all that. What are we seeing around that as it comes to privacy, or just AI laws in general, where you're not supposed to be doing that? Things like that. What do we have? Who wants to buzz in and answer that?
Tom, it's telling that you're not reading the privacy policy before you click yes, because they're already putting the language in there.
I was just about to say that. It's already been updated. You just haven't paid attention to your emails.
I just want it to work, so I say yes. Okay, fine. But I mean, we are seeing that though. We're seeing mass adoption of that. It's already in there. You're looking at me like I'm dumb. I am. So
yeah, businesses are putting in their privacy policies the rights to use your data to train their AI models. And these updates, I think the real question is, when we roll out an update now, do we have to email you about it? Do we need a new opt-in? I mean, there's a lot of consent mechanism questions around updates to reflect these new AI terms. But the terms are definitely getting embedded in there.
Interestingly, on that piece, Mariah, I was reading Minnesota's law the other day, because that's what one does when they're on vacation. And I thought it was interesting. They expressly say in there that if you make a material change, you need to email it. You need to inform, which I think we're seeing that more, right? That was like an open question under a lot of different laws. Now, what is material could be argued on, until the sun goes down. But I thought that was an interesting shift. Yeah. I would say from an AI perspective, I think there was this big push for AI in the last, like 12 months ago, right? And everything was super fancy and et cetera. And I think that from at least my perspective, there's a lot of interest in AI. There's certainly a lot of recognition. I see it sneaking into a lot of contracts in different ways. But I wouldn't say this sort of AI frenzy, the like, I need an AI policy, I need all this stuff. I feel like it's still there, but it's not as heightened. And I don't know if it's just summertime. I don't know if it's just the way people are shifting, but I think I just haven't seen it be as aggressively sort of a top of mind thing. I mean, everyone likes to talk about AI, but actually doing something and needing to take change or make any changes is less impactful recently, I would say.
So we just got a question that popped in. Can AI companies be sued if they're using your data for LLM processes without your consent? I mean, I guess how did you know that? But I mean, could I potentially sue a TikTok type organization? Now, granted, I know they've got like a privacy policy that's ironclad, but say there was it didn't say that in there. Could I sue somebody and be like, hey, you're using my likeness or my voice for stuff?
So I'll jump in. I mean, the FTC has already brought enforcement actions for this specific situation, right? So there was this EverAlbum consent decree a few years ago where this company EverAlbum was using allegedly biometric information to train their AI models without affirmative opt-in consent, which is what the FTC said they were required to have. And the agency required them to delete and destroy the model. So we call that algorithmic disgorgement, and that's a pretty heavy hammer. So from a regulatory perspective, the FTC would say, absolutely, we can come in and enforce, and we can make you disgorge your models and your algorithms if you are training them or developing them on personal information that you don't have the consent to use.
Wow.
I think we need a dictionary to keep up with Mariah. I just love the way she speaks. I love the words choices and new words of describing things that we're seeing in this universe. I would also say it boils down to, when people ask us about AI policies from a preventative standpoint, is just really focus on the inputs and outputs, right? Inputs and outputs are like the language that I seem to be kind of becoming universal. So we're not trying to complicate it with the legal world, but I do want to highlight that a lot of law firms, and maybe even your external counsel, if you don't have someone that knows technology or cyber, give a call to Jordan and Mariah, because there's a lot of law firms that actually their own firm are saying, we are not allowing any AI, any use of it, or even advising on it. And I think that that's a little bit backwards, but it's another reason you need to have very capable cyber and technology counsel.
Mm-hmm. So I'm thinking about this, and I'm traveling back in time about 15 minutes ago. So back to the Chevron thing. I feel like I'm beating a dead horse here, but the Chevron thing now, so with the AI and Chevron, now you've got some brand new bleeding edge technology that's out there that really a lot of people don't even really understand. They think it's magic, it's robots, whatever. And now we're going to have some judge that doesn't know anything about that make decisions about organizations and how they're going to do business. That makes no sense to me. I'm sorry. That just sounds dumb. Am I wrong? I mean, somebody? Violet, you look like you just want to say something.
I think I'm scared of what to say because I don't know how how this is gonna shake out. But I actually did a LinkedIn Live last night with 3 of the privacy people that I love, and they're very vocal. And one of them just predicted too that it's not gonna be years till we figure this out. We're gonna start seeing this immediately start taking different shapes, and I don't think we know how to predict it, because I think another thing that we should consider is, as Jordan showed wonderful deference to our judges and the place that they hold and the civic duty that they have. That's great, but I think it's also important to say different jurisdictions, there may be relationships that we don't know about that they have with technology or with private businesses. There may be opportunity. I mean, there are cases of judges coming off the bench for cases of fraud or issues. And I think just keeping in mind that these are also humans that don't usually interact with technology. They're not even on the computer all day because they're behind the bench. And they have clerks and people to help them with the technology. I just think it's important to acknowledge the humans behind it too, to add to the volatility. So I don't have an answer for you other than I've heard predictions that we're going to start seeing more litigation inevitably, and we don't know if that's going to turn into good law or bad law.
I would jump in and say, well, first of all, there's a comment that maybe attorneys need some technical training, and I think maybe judges need some technical training. And we do have this idea in the judiciary of special masters. So sometimes in really complex matters, we can draw in a special master and they can sit in like a quasi-judicial role. But I did want to mention that the Supreme Court a year or 2 ago heard a case. It was the first sort of algorithmic liability case. And a quote from Justice Kagan, which has been widely distributed, is, we're not like the 9 best experts on the internet. And that is true. I mean, that's them. That's the highest court in the land acknowledging that they don't really have the technical skill set and expertise to interpret a lot of these new technologies. So yeah, Tom, I mean, we might be in a situation where we have a new technology, we have an old law, right? Because Congress is not keeping up, we're not implementing or promulgating new laws. And we have a judge in the middle who has no technical background being called to interpret whether the technology is compliant, whether it violates the law, whether it has caused a harm, et cetera.
Appreciate that. Thank you. I'm going through the Q&A.
Tom, I saw one question I can jump in and answer. There was a question about EU privacy and AI.
Yes, so I was going to ask you that one.
Quickly. Yeah, so the EU did adopt their AI Act, which is not dealing with privacy. It is an AI Act. It's around the artificial intelligence tool and when it can and cannot be used. It's based off of sort of a risk analysis. So the idea is you have high risk use cases that are completely banned, and then you have sort of lowering tiers of risk that are allowed, but you're going to have different obligations based off of where your processing sits. It does deal with privacy in the sense that data it's ingesting, if it has privacy impacts, right, could have higher risks associated with it. And then the GDPR is still going to be in effect. So just because you're using an AI tool doesn't take you outside of the GDPR world. You could be using an AI tool and therefore subject to both the AI Act and the EU's GDPR. Not to mention there's a number of other sort of more technical laws that have come into effect recently, like the Digital Markets Act, et cetera. So the long and short of it is, yes, there's an AI Act. I think if you are dealing with artificial intelligence and you plan to offer it in the EU marketplace, you need to be looking at that act because it's going to go into effect, and then you're going to need to be expected to comply with it. But what's really important is if you're dealing with AI and you have personal data that you're dealing with, you need to review how the AI Act intersects with the GDPR. And that is going to be a really interesting sort of use case. And so we're going to have to see how the regulators in Europe, handle that sort of where there's that overlap. But that is sort of right now, Europe has the de facto AI law that many are looking to sort of help guide and what the legal requirements are going to be around the use of AI.
Thank you for answering that one. I actually have an answer for JP Wilson. He was saying maybe in some way CISOs need to be trained to speak board to help assure full compliance with the new SEC cyber rule. We're actually going to be doing a webcast on that with our guys that do the cyber debrief, Cedric Layton and Vijay Viswanathan. We're going to do that, I think, in September. So check that one out. I think that one might be eye-opening for you. We're getting close on time, and I know, Jordan, you've got a hard stop at the top of the hour. So I'm going to go through a few things here really quickly. This was I grabbed an AI image. I was going to ask our panel about it. I'm not going to ask them about it, but this is just my interpretation of the Supreme Court right now. You guys don't have to agree with me. I don't care. That's my thought. Again, my opinion, not SecureWorld. You can hate me all you want. SecureWorld's cool, so don't hate on SecureWorld. Anyway, that's my thought, but I wanted to end on a happier note, if you will. So we'll have a nice flower instead, right? So final thoughts. We've got a ton of questions that we didn't get to, and I'm sorry, but I learned a lot, and I hope everybody out there did. We're going to do this again probably in about 2-3 months. Once a quarter is kind of what we've been doing. So Jordan, if you wouldn't mind, give us some final thoughts. And what I wanted you to do on this one, instead of like homework and stuff, but like cyber fatigue is real. What do you do? Obviously, you're reading Minnesota state law. That's not going to really help a lot of folks. But what do you do to help get rid of cyber fatigue?
Oh, geez. I think, and I was going to say this even before you asked the question, but I think it still aligns with it. Don't get distracted by everything that's going on, right? I think in some ways you have to hone in on what's relevant to you, what's important to you, come up with a plan and really try to execute on that plan. And I think there's a lot that's going on. I don't mean to imply that you should be sort of keeping your head in the sand and not paying attention, but I think the core privacy and security requirements that have now been in effect for a number of years are still there. They're still going to serve you really well. And focusing on that and not getting too distracted by all the myriad of commentary and the breaches and everything, I think that's for me how I address cyber fatigue. Because otherwise, I could read the news 24/7 and still feel like I'm not caught up. And so you at some point need to figure out what's your path forward and how do I make this relevant for what I need to do for my clients, you need to do for your business, your job, whatever it is, and try not to get too distracted by everything that's going on, because the basics are still going to be really good for you as you move forward.
Awesome. Thank you so much for being here. You are free to go. So thank you so much. We'll pop over to Violet Sullivan for your final thoughts. And what are you doing for
I just realized
fatigue?
I have a top of the hour meeting also.
Oh.
So I will jump in to say, well, one, I look forward to doing this every couple months with this group. And even if I wasn't on there, hold on, I need to decline a spam call. Even if I wasn't on this, I'd be watching it. I think the way that I fight fatigue is, well, it depends on if you're introvert or extrovert. I'm an extrovert, so I really enjoy swapping ideas with thought leaders and admitting I don't know things and going and learning and listening. So I'm probably a lot more, like, I'm not as directed as Jordan just said to be, which I think is really good advice. But sometimes if you can get creatively stimulated by the subjects, go and seek those things that you're stimulated by, so that you can then turn that energy and focus on the applicability.
Appreciate that. Thank you so much, Violet. And we'll see Violet again later this month at the AI virtual conference. There's a link in the resource tab, and she's got a bail. So we'll see you at the AI conference. Mariah, take us home. It's all you.
Let's do some closing thoughts. I'll flip the narrative a little bit and say you are in the coolest space, most evolving area of, law or of industry, privacy and cybersecurity, there's an enthusiasm that you can maybe tap into, and a passion for this subject area. Yes, it's a lot. Yes, there's a ton of changes, but there's industries that are very staid and very monotonous and very well established and don't have as much volatility. I think maybe finding some passion in the fact that we get to keep up with this, we get to be in the news. It can be kind of a cool maybe flip of the switch. But anyway, thanks so much for having us, or having all of us and having me. I appreciate it.
Always welcome, Mariah. You're free to go. I'll wrap everything up here. And I just want to echo, all of you out in the audience, you're all cyber heroes to me as well. And I know that sounds kind of kumbaya-y, but we're all in this together, right? So as you're going to the different events, if you go to our in-person SecureWorld events, find one of these, because you all deserve one. Go to the front desk. I think that's where we have them all. Cyber hero. You guys are all cyber heroes. So not only you get a CPE credit for attending, I gave you a good lead on some free merch, right? So hit up PJ and Anna at the front desk at registration if you're attending any of our in-person events. But speaking of, actually, I want to say just thank you. You guys just saw them all, but Mariah, Violet, and Jordan, I want to say thank you for their time. They are awesome. They are just a pillar of knowledge for me. So I always reach out to them. If you need help, reach out to them. Their contact information is in the bio bar down there at the bottom of the menu bar. But we have more stuff coming up. I've also got in the resource tab, we've got all of these loaded. There's actually one place you can go and sign up for all of them at the same time. So we've got Blue Team Academy Risk and Risk Notables for analysts. That's coming up next week on the 18th. Looks like I'm missing a couple on here, actually, that I see that. I've actually got one tomorrow on CTEM that you're going to want to check out. And there's also one on the 16th, which is the IT Admin's Guide to Safe Automation. So again, that's part of that one registration link that you can go and actually sign up for all of them at the same time. So watch out for those. AI is on the 24th. That's an all-day event. You'll get 6 CPE credits for attending that. That's completely free. So check that out. And like I said, go to our in-person events. If we've got one in your neck of the woods, please come visit us. We'd love to have you there. So that concludes law, cyber, and privacy concerns for 2024. We're going to do this again in Q4 at some point, so watch for that. We'll be sending out announcements for that. If you haven't already, grab your CPE credit down there at that widget bar down at the bottom. And we'll see you tomorrow on our next remote session. So be well, everybody. Take care. Have a great day.